Ninti El Bey, the owner of the property located in Piper Glen, Charlotte, North Carolina. This is an intro to the court case, Ninti El Bey versus the state of North Carolina and city of Charlotte. The judge clearly laid it out in law what the proper protocol is in dealing with the person who has claims on the property, not arbitrarily putting your hands on the person and their family and ejecting them without warrant, without probable cause, without any court order of any kind. This is going to be a prime example that we are in a time, and we have embarked on a time that the average person is going to be smarter than the attorneys, the judges, the people in municipalities and in quote unquote high places. And of course, smarter than the law enforcement arm. And this is called what's in biblical terms, where the first is the last and the last will be the first. And I am ushering in that spirit by example.
Brief and support. Basically, what the city's asking is that the case be dismissed pursuant to Rule 12b-6 with prejudice for failure to state a claim upon which relief to be granted. The city's position is the facts as alleged establish probable cause for the plaintiff's arrest for second-degree trespassing.
Well, isn't the standard here that we assume what is alleged in the complaint to be true?
Yes, sir.
And she alleges she is the owner of the property.
Well, she actually alleges she's the owner, she's the tenant, but all of her claims of ownership or tenancy, assuming they are true, are based on the mistaken belief that as a member or associate with the Moorish nation, if you look at page 20,
well,
she's
she doesn't say how she owns the property.
Well, actually, if you look at page 20, she's claiming ownership or title to the property through, I believe it's an aboriginal trust.
Are you Miss El Bey?
Yes, sir.
All right.
I came in and there was a hearing going on. I didn't know if this might be right next. So I'm going to listen.
You're not going to mention
That it's not clear to me,
well,
having read the
on
complaint.
page 20, she claims there's no higher claim to property and land ownership in these United States of America than aboriginal title. The secured party plaintiff possesses aboriginal title.
Well, but that's in an exhibit list in a statement, not in the actual pleading.
Thank you.
She alleges in other places she is the owner of the property. Now, it is not defined in any detail on what theory she is the owner of. But she alleges
Well, I mean, I would refer the court to paragraph 2.
I can't hear you talking.
Oh, sorry. I would refer the court to paragraph 2. She does seem to, certainly the reasonable inference from the facts and allegations in the complaint is that the only way by which she claims title to the property is through her association with the Moorish nation. Also, she references a deed that the authorized representative of the property owner, J.P. Morgan Chase, Chase Bank presented to officers
The mere
on.
existence of a deed on one date doesn't prove ownership of property 6 months later.
But
There's
again,
nothing that says,
assuming the facts as alleged is true, what officers on scene were presented with was, according to her allegations, an authorized representative of the owner of the property presenting a deed or title to the property. So the question for officers then, did they have reasonable or probable cause to believe, based on the representations of the authorized representative of the bank on the scene that day, to establish the elements for second-degree trespass?
there was nothing in the pleadings to the effect there was a court order for eviction or removal.
Sure. Sure, for someone who admits to squatting on the property later.
She's not,
No
she
one ever
doesn't
admitted to that.
allege, I mean, the allegation that
I think
she's
the
squatting.
allegation is that, excuse me, the allegation is that officers, under the presumption she was squatting on the property, arrested her for trespass. The facts as
What
alleged.
she's
in the
saying
complaint.
is, I own the property. I told them I owned the property.
Well,
And they
she's,
arrested me on my own property and took me off. Now, whether she can prove that,
she actually claims tenancy and residency of the property.
and she also claims ownership.
I see legal tenancy, paragraph 11, page 3, legal nature of plaintiff's residency, paragraph 14, also on page 3, paragraph 19, legal documentation to be occupying the property on page 4.
She says the legal nature of her residency.
Yes. Then paragraph 29, page 4, ancestry documents for indigenous peoples. She does in paragraph 43 on page 6 claim it is her home. However, she talks about Miss Kennedy demanding an eviction in the middle of paragraph 43 on page 7. Again, references evidence of her right to be residing in the home. Page 7. Also in paragraph 43. And then she does, although I guess in an exhibit list, claim aboriginal title on page 20. So I think the reasonable inference from that is she is claiming legal lawful tenancy.
I mean, the problem is, I'm judging it on a motion to dismiss, all material factual allegations are taken as true or deemed admitted.
Sure.
So I'm kind of not in a position. I mean, she doesn't allege in her pleadings, I'm squatting on the premises.
No, but she's claiming lawful right to the property
Right.
based on her association with the
Well,
information with the court.
she
I
doesn't-
object to that.
She doesn't fully specify what her legal basis is. At summary judgment, or when somebody came in saying, I've done a title search of the land records of the property and here's what they show, then we got a different matter.
Again, I think even taking that she was a lawful tenant, the other facts as alleged still establish one party present, the owner of the property for the bank. Contesting, because to defeat her claims, all we have to establish is the facts as alleged establish probable cause for the arrest. We don't need to establish, was she a lawful tenant? Was she a valid or lawful owner to the property? The facts as alleged simply need to establish probable cause for the arrest. And again, that's a reasonable or probable grounds for the officer present to believe at the time, based on the facts as alleged, they had probable cause cause to arrest the plaintiff, and I believe the facts as alleged establish probable cause, even given the competing factual allegations contained in the plate for officers on scene to make the determination that probable cause existed for the arrest. I'm sorry.
It's basically saying there were false statements made to her. She was wrongfully arrested for trespassing on her own property. So, I mean, I think she's got claims in here. I mean, she doesn't really allege false arrest
I allege that in my
by
motion.
labeling it that way. But
Your Honor.
I'm still bothering him right
Okay.
I thought there were
now.
several places where she
fact that
alleged
you
false
don't have
arrest.
to correctly label your claims.
Sure.
And whether this can all be proven is
Sure.
maybe a different matter, because it seems to me her whole claim is premised on ownership of the property. If she doesn't own the property, then everything seems to me collapses.
Sure. But I thought there were several places where, if not properly labeled as such,
Yeah. she
she made out a claim, albeit a factually insufficient one, to allege false arrest.
I mean, it's, and
There were no,
it doesn't strike me as, I wouldn't provide this complaint to law students in law school to say this is how to do it, but it seems to me it does suffice to allege a theory of I own this property, I was lawfully on the property, I was hauled off the property, there was no eviction order or a court order to authorize this.
right, but I think she does allege a representative of the bank, the owner of the property, was present.
Right. Well, they were claiming,
Allegedly.
they had two people there claiming the property.
Sure.
And
And officers.
if she's in fact the owner and they know she's claiming it, they're kind of taking their risk, and it's not clear what the proof was that was being offered to them at the time.
And the complaint is devoid of any proof or evidence of ownership. So officers are faced with the he said, she said, or she said sort of situation. Officers all the time must make the determination.
And many times the officers will say,
Sure.
y'all go to civil court, so everybody hire a lawyer, and y'all go litigate that up on the
Thank you.
6th floor of the courthouse.
Sure.
And let's figure out who owns it.
Judge, and I will, without wanting to stray too far, outside of the complaint, the court, I think, could take notice of the fact that court records or public records indicate Ms. El Bey was convicted in district court of second-degree trespass.
But did she
So
plead guilty to that, or was that a trial?
It was a trial.
Yeah.
However, both the Burton and the
Yeah,
Myron
because,
case.
I mean, I don't have that
Sure, but
in the record on a 12b6. The court's sort of vaguely aware of things the court, somebody said once, the Supreme Court follows the election returns. I think you could truthfully say the Superior Court judge just read the paper.
Sure, but I don't know that taking notice of what is otherwise a public record
Yeah.
would necessarily convert the motion into a 12b6. I have the line of cases in there where the court can at least take reference or notice and consider for the purposes of 12b6 documents referenced within the complaint, which would contend would be at least the deed at issue with regards to the property as of September 20th that was attached as an exhibit to our brief in support. But both the Burton and the Myron case stand for the proposition that even if appeal, the finding of guilt in a district court case would bar plaintiff's action for false arrest. And I have those cases if the court would like me to approach.
What's that?
Burton as well as the Myrick. It's Burton versus City of Durham and Myrick versus Cooley, which stand for the proposition that a conviction in District, well, probable cause, first step. The existence of probable cause for an arrest defeats all claims for a civil rights violation for false arrest,
Well,
as well as further the fact that conviction in district court does the same.
are those things on appeal to the Superior Court Division?
Yes,
Even-
yes, and 4 of them were already dismissed of the same.
Well, I'm just trying to ask
I
you.
would say Myrick versus Cooley states that even if they are on appeal, the finding of guilt is binding unless there's an allegation that the conviction or finding was improperly or fraudulently And I have those cases.
Let me see those. What else you want to tell me?
Your Honor, even if the plaintiff's claim for false arrest survives the motion to dismiss, the city would ask you to dismiss any and all claims related to the Declaratory Judgment Act pursuant to Rule 1286. Take a look at the actual relief. She is seeking their claims, again, based on the Morris Nation, which previous courts or other courts have found really have no legal purchase in state or federal courts of law. Additionally, she's alleged complaints that are without any factual or legal support for their existence. In particular, she's alleged causes of action under federal criminal statutes as well as Juvenile Code, Chapter 7B of the North Carolina General Statutes, as well as perhaps there's a laundry list of sort of complaints 160A, 285, I believe. So the court would ask that those causes of action, as they are pled, are either factually insufficient to have pled a cause under which relief could be granted, or are legally non-existent. With regards to her, it's the fourth count violation on page 13, alleging that officers violated her Fifth Amendment rights under Chavez versus the United States. That claim is factually insufficient. A mere failure to recite one's Miranda rights is insufficient to allege a cause of action under 14 U.S.C. 1983. She's lacking any allegation that any statements made pursuant to that prophylactic rule and not a constitutional right is addressed better in criminal court where the statements might be suppressed. So any barring or in light of the lack of any allegation that those statements were used to trial, that cause of action is also factually insufficient. Similarly, even taking the allegations as true, the plaintiff has failed to allege factually any necessary or sufficient facts to support really any negligence, and really any tort under state law, whether it be through negligence or an intentional. Specifically, she tended to allege both negligent as well as intentional infliction of emotional distress. It's lacking necessary evidence to show that there was any egregious conduct. Pretty much taking the facts as true, officers were faced with a situation where there were two competing parties professing an interest in the property, and they made a determination based on that to arrest her for trespass. Lastly, would ask that any and all causes of action and that the individually named defendants be dismissed as parties to the lawsuit pursuant to the North Carolina Rules of Civil Procedure. She named them both individually as well as officially failed to properly serve Chief Putney, Lieutenants Kitchens, Lieutenants Lisenby, Lieutenant Pardue, as well as Sergeant Anderson. And then lastly, line cases in there cited with regards that any and all claims against the Charlotte-Mecklenburg Police Department be dismissed. She's properly named the city.
Mrs. Ninti.
What her legal basis is at summary judgment, or when somebody came in saying, I've done a title search of the land records of the property and here's what they show, then we got a different matter.
Again, I think even taking that she was a lawful tenant, the other facts as alleged still establish one party present, the owner of the property for the bank. Contesting, I mean, because to defeat her claims, all we have to establish is the facts as alleged establish probable cause for the arrest. We don't need to establish, was she a lawful tenant? Was she a valid or lawful owner to the property? The facts as alleged simply need to establish probable cause for the arrest. And that's a reasonable or probable grounds for the officers present to believe at the time, based on the facts as alleged, they had probable cause to arrest the plaintiff. And I believe the facts as alleged establish probable cause, even given the competing factual allegations contained in the plate for officers on scene to make the determination that probable cause existed for the arrest. I'm sorry.
It's basically saying there were false statements made to her. She was wrongfully arrested for trespassing on her own property. So, I mean, I think she's got claims in here. I mean, she doesn't really allege false arrest
I allege that in my
by
motion.
labeling it that way. But
Your Honor.
I'm still bothering him right now.
I thought there were several places
The
where she
fact
alleged
that you
false
don't have
arrest.
to correctly label your claims.
Sure.
And whether this can all be proven is
Sure.
maybe a different matter, because it seems to me her whole claim is premised on ownership of the property. If she doesn't own the property, then everything seems to me collapses.
Sure. But I thought there were several places where, if not properly labeled as such,
Yeah.
she made out a claim, albeit a factually insufficient one, to allege false arrest.
I mean, it's,
There were no.
it doesn't strike me as, I wouldn't provide this complaint to law students in law school to say this is how to do it, but it seems to me it does suffice to allege a theory of, I own this property, I was lawfully on the property, I was hauled off the property, there was no eviction order or a court order to authorize this.
Right, but I think she does allege a representative of the bank, the owner of the property, was present.
Right. Well, they were claiming,
Allegedly.
they had two people there claiming the property.
Sure.
And
Officers.
if she's in fact the owner and they know she's claiming it, they're kind of taking their risk, and it's not clear what the proof was that was being offered to them at the time.
And the complaint is devoid of any proof or evidence of ownership. So officers are faced with the he said, she said, or she said sort of situation. Officers all the time must make the determination.
And many times the officers will say,
Sure.
y'all go to civil court, so everybody hire a lawyer, and y'all go litigate that up on the
Thank you.
6th floor of the courthouse.
Sure.
And let's figure out who owns it.
Judge, and I will, without wanting to stray too far, outside of the complaint, the court, I think, could take notice of the fact that court records or public records indicate Ms. El Bey was convicted in district court of second-degree trespass.
But did she
So according
plead
to-
guilty to that, or was that a trial?
It was a trial.
Yeah.
However, both the Burton and the minor
Because,
case.
I mean, I don't have that
Sure, but
in the record on a 12B6. The court's sort of vaguely aware of things the court, somebody said once the Supreme Court follows the election returns. I think you could truthfully say the Superior Court judge just read the paper.
Sure, but I don't know that taking notice of what is otherwise a public record would necessarily convert the motion into a 12b6. I have the line of cases in there where the court can at least take reference or notice and consider for the purposes of 12b6 documents referenced within the complaint, which would contend would be at least the deed at issue with regards to the property as of September 20th that was attached as an exhibit to our brief in support. But both the Burton and the Myrick case stand for the proposition that even if appeal or finding of guilt in a district court case would bar plaintiff's action for false arrest. And I have those cases that the court would like me to approach.
What's that?
Burton as well as the Myrick. It's Burton versus City of Durham and Myrick versus Cooley, which stand for the proposition that a conviction in district, probable cause, first step. The existence of probable cause for an arrest defeats all claims for a civil rights violation for false arrest, as well as further the fact that conviction in district court does the same.
Are those things on appeal to the Superior Court Division?
Yes, and 4 of them were already dismissed of the same.
Well, I'm just trying to ask.
I would say Myrick versus Cooley states that even if they are on appeal, the finding of guilt is binding unless there's an allegation that the conviction or finding was improperly or fraudulently obtained. And I have those cases.
All right, let me see those. What else you want to tell me?
Your Honor, even if the plaintiff's claim for false arrest survives the motion to dismiss, the city would ask you to dismiss any and all claims related to the Declaratory Judgment Act, pursuant to Rule 12b6. I think if you look at the actual relief, she is seeking their claims, again, based on the Moorish Nation, which previous courts or other courts have found really have no legal purchase in state or federal courts of law. Additionally, she's alleged complaints that are without any factual or legal support for their existence. In particular, she's alleged causes of action under federal criminal statutes as well as Juvenile Code, Chapter 7B of the North Carolina General Statutes, as well as perhaps there's a laundry list of complaints 160A, 285. I believe, so the court would ask that those causes of action, as they are pled, are either factually insufficient to have pled a cause under which relief could be granted, or are legally non-existent. With regards to her It's the fourth count violation on page 13, allegation that officers violated her Fifth Amendment rights under Chavez versus the United States. That claim is factually insufficient. A mere failure to recite one's Miranda rights is insufficient to allege a cause of action under 14 U.S.C. 1983. She's lacking any allegation that any statements made pursuant to that the court had called a prophylactic rule and not a constitutional right is addressed better in criminal court where the statements might be suppressed. So any barring or in light of the lack of any allegation that those statements were used to trial, that cause of action is also factually insufficient. Similarly, even taking the allegations as true, the plaintiff has failed to allege factually any necessary or sufficient facts to support really any negligence, any tort under state law, whether it be through negligence or an intentional. Specifically, she attempted to allege both negligent as well as intentional infliction of emotional distress. It's lacking necessary evidence to show that there was any egregious conduct. And pretty much taking the facts as true, officers were faced with a situation where there were two competing parties professing an interest in the property, and they made a determination based on that to arrest her for trespassing. Lastly, would ask that any and all causes of action and that the individually named defendants be dismissed as parties to the lawsuit pursuant to the North Carolina Rules of Civil Procedure. She named them both individually as well as officially failed to properly serve Chief Putney, Lieutenants Kitchens, Lieutenants Lisenby, Lieutenant Pardue, as well as Sergeant Anderson. And then lastly, cases that were cited with regards that any and all claims against the Charlotte-Mecklenburg Police Department be dismissed. She's properly named the city.
I mean, you don't sue the police department, you sue the city, and it gets the same people.
And while that could be corrected, she has properly named the city, so we just ask that the department be dismissed as part of the lawsuit. It is not a legal entity capable of being sued.
Yes, ma'am.
Okay, Your Honor, I have before you today my answer and a motion to show cause for the CMPD officers. If I could give this to you so that you can follow me tonight in my exhibits. First off, Your Honor, I would like to say that the cases that were brought against me for trespassing and breaking and entering were improperly applied.
I need you to speak up.
This help?
No,
Oh,
that's not a microphone.
oh, okay. Counsel, what's your name?
Mr. Perlinger?
Mr. Perlinger made mention of the trial and the cases that were brought against me on March 1st for the trespassing and the breaking and entering, Your Honor. There were 3 breaking and entering and 3 trespassing charges that were brought against me within a 3-week period. And I challenged that in the court session. 4 of the charges were dismissed, Your Honor. And I don't know, for whatever reason, the others weren't dismissed because they fall under the double jeopardy rule. These officers targeted me and profiled me for a 3-week span, arresting me for the same charges over and over again without allowing me to be heard on the first charges. It's a series of redundant charges of the same charges, first of all. Second of all,
Object that the plaintiff's complaints solely relates to the United events that occurred, I guess
Yeah,
on
I'm
or
just-
about October 20th. There was nothing subsequent that occurred with regards to any
I'm
It was-
allegations.
trying to figure out
Yes,
what she's.
it's affidavit.
Yes,
Yeah.
Oh, I filed several affidavits after the complaint in support of that complaint to identify the latest issues that were happening as they were happening. So it is in the file. It's a big book, but you'll get to it if you get a chance to read it. It's in there. I answered his motion for this dismissal. And what I say to that is I have claims for which relief can be granted. The false imprisonment, of course, under North Carolina General Statute 1-52, Section 19, pursuant to North Carolina General Statute 1-52-3, the ethnic animosity, pursuant to thirdly, pursuant to North Carolina General Statute 14-3, B and C. Then, of course, the Title 42, United States Code 1983, deprivation of rights under the color of law. Number 5, pursuant to 1-5213, I'm claiming against a public officer for a trespass under the color of his office, and there were 20 of them. Lastly, there's been an egregious amount of abuse of process, Your Honor, in my case.
Go ahead.
I was saying, lastly, there has been an egregious amount of abuse of process in my case, Your Honor. This is the second time in a 5-year span that I've been targeted and attacked by Charlotte-Mecklenburg Police Department. There is a profiling that goes on with people who claim more status, so I was immediately targeted by my name. I immediately gave the police department my lawful claim to the property, which stems from a private agreement that I've had with J.P. Morgan and Chase, which was initiated during my capacity as a mortgage broker, lender, and servicer. If you go to the tab that says my credentials towards the back, you will see my credentials as a licensed mortgage broker, servicer, and lender's license. I'm licensed broker in 2 states. Your Honor, I have a long, vast history in the real estate industry. I'm an expert witness for Thompson and Rudders. So, you know, their claims of all of this media hoo-ha all over the news is an attack on anyone claiming a Moorish heritage or a Moorish status. And that's the only reason I'm bringing this up, because they always bring it up. I'm standing on law, and the law that I'm standing on is pursuant to the Uniform Commercial Code. This was a private contract based on a creditor-debtor relationship for the last several years from the alleged bank that these officers claim to be acting for. They overstepped their bounds. This alleged bank has not come forward to corroborate any of the police officers' claims or this real estate agent's claims. They did not state a claim against me during the trial on March 1st, 2016. In fact, I have not been challenged. My claim of interest in the property has not been challenged by this alleged bank. They have not brought any claims against me. There is no injured party. Charlotte-Mecklenburg police officers overstepped their authority, impeding on my private contract without probable cause to do so. The charges of trespassing and breaking and entering were improperly applied. And 4 of the charges were already dismissed by the DA. And I am confident the rest of them are under appeal because they fall under the double jeopardy theory, to where they just kept coming in my neighborhood harassing me for the same thing. Even when I had a court order to enter back into the house, I temporarily restrained a real estate agent who hadn't produced any authority when they came out there on October the 20th. I had my documentation that was filed in the county. There's a certified copy in there. That's going to be your second tab. Certified copy from the county in which I'm claiming my claim of interest. I showed the officers this. The real estate agent.
Do you have somewhere in these materials the document that gives you title or ownership to the property?
The title to the ownership of the property stems from, if you want to go to the tab where...
How about if I do this? I mean, hand this notebook.
It's number 2.
To the courtroom officer, and let me get you to pull out for me the document that gives you title to the property, so I can make sure I understand.
And then this...
Okay, so, I mean, I want to get the notebook back because I want to make sure I have a chance to read it and review it. But what I'm seeing that has been the document that gives you title or ownership or a legal interest in the property, I gather is actually seeing 5 pages of documents.
Yes, Your Honor.
The first one has a certified seal on it that talks about from the Register of Deeds office. The next one is a document that does appear to be filed in the Register of Deeds office that is entitled Notice of Intent.
Yes, Your Honor.
And it's a 1-page document. It's also sealed.
Yes, Your Honor.
It appears to be the document that the prior basically this certified.
That just came today. They didn't have the certification,
The
but they had
second
the
notice
stamp.
of intent seems to be the document that these
That's
two go
correct.
together.
That's correct.
Then there's a document that is a UCC filing acknowledgement entitled the International Trust, care of Peace Palace, The Hague.
Yes, Your Honor.
And that's a 1-page document. The next document is, and actually that first document is, I'm assuming this is a Secretary of State's number.
Yes.
B30287-P969.
Yes, Your
The
Honor.
next page has the same numbers, but it's P970 that says that it is a UCC financing statement.
Correct.
Okay? And then the last document is P971, a UCC filing statement.
Identifying the legal description, correct.
So what you're telling me is the documents that create your legal claim are these pages that I have here. Is that correct?
Yes, Your Honor. That's the evidence of it. As I said earlier,
Okay. And are you wanting me to consider these documents in resolving this motion I've heard today?
resolving I'm not done in my
Well, I'm
testimony.
not saying you're done. I'm just wanting to know if you
That
have any
is the
objection
evidence.
to me considering these documents in terms of me figuring out what to do today.
No, that's fine, Your Honor. I
Okay.
presented that to the police officers, and
All right.
and that's fine.
All right, now that I understand that, go ahead.
Okay, so based upon that, upon the time of me showing them and giving them this, and in fact, I sent a copy of this to the police department, chief of police, and his attorney, executive, Brian Cunningham, before I even came to town, letting him know the lawful status of which I was claiming and my relationship to this house and with this bank. So I have all proof of that, the emails and the confirmations and everything. So they already, the higher ups already knew that I was in this house. The police officers came out when I showed them what I had, and I kept telling them, you need to contact the chief of police. They were taking me for a joke. They figured that I'm, you know, a criminal. I don't have a criminal history. The only history I have is when I came to Charlotte, North Carolina, and I have an arrest record from police officers targeting me and profiling me. If you can go to the tab that says charges dismissed, you will see the first charge, the 4 charges that were dismissed on March 1st, 2016, the trespassing and the breaking and entering, and a couple of vehicle charges were dismissed. You'll see the 2010 cases from CMPD officers harassing me and profiling me, showing a pattern of this behavior towards me and others who carry the name El Bey. These charges
Let me interrupt you again, ask you another question.
Yes, sir.
That the court is generally allowed to take judicial notice of other court files.
Mm-hmm.
Do you have any problem if after the hearing I get the clerk to pull me these file numbers so I can look at the actual files and see what the status is?
I don't have any problem with it.
Okay.
I got a copy right here of the appeals.
Well, I'll just, I'll pull
That's
the whole
fine.
file. You have any problem with me doing that?
No, I don't have a problem.
City
with
have any
that.
problem with that?
Actually, Your Honor,
Well, I'll
if
just.
there's no objection, I got a certified copy.
Well, I'll just get the whole, look at the entire files.
As I stated, the remaining charges are charges of a excessive nature, Your Honor. They're derived from the same poisonous fruit, from the same poisonous tree, fruit from the same poisonous tree as the first charges that were improperly applied. They charged me 3 times with trespassing in a 3-week period, 3 times with breaking and entering in a 3-week period, with the intent to harass. And they admitted on the stand on the 3rd that they had premeditated coming out there. So they went looking for a real estate agent to come over there and use her as a scapegoat. They got on the stand, Officer Anderson got on the stand and stated that he already knew my name, he already knew my birth date, he already knew everything about me before he got there.
Okay.
And the other officer got on the stand and admitted that they did research to find out who was possibly an agent on the house and all of this stuff, and he gave her legal advice. It's all in the transcripts. He gave her legal advice to come over to the property to put me out. And she got on the stand and could not produce any lawful delegation of authority. Like I said, I subpoenaed JP Morgan and Chase. They did not, they're standing mute. The attorneys for this real estate agent have no claims against me, no valid production of any type of delegation of authority. They produced something that did not identify the property. They put warrants out on me in the name of JP Morgan and Chase. When they got on the stand on the 3rd, they said that they didn't work for JP Morgan and Chase. So now that I'm subpoenaing everybody and filing state bar complaints for false representation, they want to backtrack now and say they don't work for JP Morgan and Chase, putting all of these servicing companies in the mix of it. Now it's like 4 servicing companies. They jumping from servicing company to servicing company. Nobody wants to, it's like a hot potato. Now, none of these people that were bringing claims against me want to deal with it now because I know what's going on. It's all with the intent to harass, and there is evidence of that. It was a conspiracy to harass me. Channel 9, there's this real estate agent involved. The police went and got all of these people. After they targeted and profiled me, they went and got this real estate agent and found her. Her contract on the house was expired on the day of when they came over there. So they had to hurry up and make a move with her because her contract was expired on October 20th, the one that she produced for court. And it still didn't give a delegation of authority from JP Morgan and Chase. There's an article in Channel 9 News from Councilman Edmund Driggs, who indicated that I was using loopholes in the law, and they were going to get me out regardless. Okay, so this is a conspiracy amongst CMPD, Janan Kennedy, the real estate agent, Edmund Driggs, a councilman, several attorneys from the law firm Nelson Mullins, Riley, and Scarborough, which I've had to file complaints against regarding this whole issue of them violating and depriving me and my children. That's why there is a count in that complaint for my children's sake. You know, they tried to taint the minds of my children, talking to them with all of these negative connotations about their mother, removed us from the property, locked me up on a false warrant, and when I was locked up, they went in the house and was going through all my personal belongings and removed them. Tried to produce a piece of paper at trial so you're admitting that you went through my stuff, one of these attorneys. And I objected and told the judge they didn't have a warrant to go in the house, they didn't have a warrant to go through my personal property, so he sustained it. The point I'm making here is, Your Honor, this was all premeditated harassment and stalking and profiling on the part of the police officers. And the proof is right here in this news article that Channel 9 has been following. They're the ones that called Channel 9. They made this big media frenzy about it. And I told the officers then, I said, you should have done your due diligence on me. You know, you're trying to paint a picture that I'm this criminal squatter. I've never been accused of squatting. I have a long history as a real estate professional, licensed broker in good standing, as I stated, Thomas & Reuters, expert witness, author, publisher. I mean, you name it, I've done it in real estate. But the main point I want to drive forward is that this is a private matter. And once I showed them my claim of interest in this property, they should have known it was a civil matter and not taken the course of abruptly removing me and my children, displacing us. I didn't know where my furniture, my clothes, my personal effects, my papers was for about a month and a half. I don't know what makes the police officers or the state or the county feel that they can abruptly abuse their authorities and deprive people of their rights without repercussion. They do it every day. But this time, I'm not standing for it, Your Honor, because I know that I've been violated. And for the sake of my children, I have to fight for them. And the copy of the complaints that I filed against these attorneys that are now backtracking is all in here. The one attorney, Travis Bustamante.
I'm not, the matter before me of what about the attorney didn't hear.
Okay, I'm just making the, showing.
The issue I've got is, do you have a valid claim against the city of Charlotte?
Okay, the valid claim is stated in the complaint, Your Honor. And also, as I stated from the beginning, the false arrest, and I cited the statute, and I'm claiming the ethnic animosity because this is a pattern that they've done to me and my children for over the past 5 years. The deprivation of rights, Title 42 U.S.C. 1983, and also I'm stating claims for relief pursuant to 1-5213. These officers overstepped their bounds under the color of their office, abuse of process, warrantless trespass. You know, this was a malicious and deliberate misuse or perversion of regularly issued court processes. They totally threw out the window the fact that this is someone's home that they're residing in, and that I was supposed to have due process to be heard in a court of law, no matter what they thought. They're not attorneys.
Anything else you need to tell me?
Claims of relief under the false imprisonment pursuant to North Carolina statute 1-5219 and pursuant to NCGS 1-523 and pursuant to NCGS 14-3 B and C, that indicates the relief of those, the punishment of those misdemeanors for the ethnic animosity and the false imprisonment.
All right. Court at this point would allow the motion to dismiss as to the Charlotte-Mecklenburg Police Department, because it is basically the city of Charlotte is the proper party, not the police department per se. Secondly, would allow the motion to dismiss for lack of service as to the individual officers. That would be without prejudice to refiling those. As to the claims against the city of Charlotte, the court having received a number of documents this morning that I hadn't had a chance to read, plus I need to get the access to the various criminal files that have been referenced in this case and look at those. Parties haven't consented to me doing that. I'll take the remainder of it under advisement, read the documents and see what to make of it. All right. Thank y'all and be in touch.
Thank you.
Thank you.
Then we got George Henderson versus Carolina Basketball Club.
Good morning, Your Honor.
Good morning. How y'all doing?
As you can see here, the judge is clearly described what needs to take place, that I come back and reserve the officers and the chief of police, and that his office wanted to review the rest of the paperwork, that I had a claim against the city or not. Now, this city attorney, Richard Rustin Perlinger, has privy, as all attorneys do, to write up the judge's final order. The judge's final order in this case would be dismissed in part as to the officers. Hi family, I'm signing books today. Get your copy. It's more than a real estate book. It's an American history lesson. Get your signed copy by the author, sent to you with a special message from Eureka M. Ramjour. Get your copy today. Myth Behind Foreclosure, Wall Street, Big Banks and You, by Girl from Detroit. Peace and love.